The war in Gaza and the Hamas attack that triggered it are often viewed through the lens of war crimes. This particular bombing, described as a war crime. Housing militants in a hospital, reported on as a war crime. But how exactly are these specific crimes defined, and how subject to interpretation are they? Rather than relying on what we see online, we thought we'd bring you an expert. I sat down recently with someone who not only teaches about the laws of war, but he actually helped negotiate the definitions of war crimes for the International Criminal Court. This is not a conversation about who's right and who's wrong. It is a conversation about how militaries, states, and tribunals distinguish between legitimate acts of war and war crime. With all the violence in Israel and Gaza of late, it seems everyone has become an expert in the laws of war, whether that's celebrities, athletes, or influencers. Today, we thought we'd hear from an actual expert on war and war crimes. We're joined remotely by Professor Mike Newton of Vanderbilt Law School. Professor, thank you for the time today.
No, I appreciate your time. I'm here to deliver a set of comments on the International Criminal Court. So this is like a perfect segue into today.
Oh, that's right. I'm not reaching in your office today, am I?
No, sorry about that.
You are not a celebrity or a social media influencer?
No. I stay busy helping judges around the world and helping put the cases together for prosecution, although I did do one defense case in my life at the International Criminal Court. Most of my work has been spent either really two prongs. Three actually. Because of my military background, a whole section of career advising commanders, things like rules of engagement, things like the real application of the law of war in a battlefield context, operational context. That's the first part of the stool. As the ICRC would always tell us, the International Committee of the Red Cross, a two-legged stool falls over. So I happen to be one of those guys that has sort of three legs. One is the actual operational experience in the field with commanders and NGOs grappling with these issues in real time. And then, of course, as you alluded to, a lot of counsel experience. But the real depth of insight and technical experience for me has come in the trial support role, working to advise both U.S. policymakers, but also policymakers and judges around the world. So the Yugoslavia War Crimes Tribunal, the Milosevic trial, and Tadic, and a bunch of others, Rwanda, Sierra Leone. I helped set up the Sierra Leone court, the special court for Sierra Leone. And then a whole bunch of work at domestic senses, helping Peru, helping Uganda, helping Bosnia-Herzegovina, now, of course, helping Ukraine. And the issues are cross-cutting issues in terms of, and I hope we can talk about this, what is the law of war? How does it work? And how do we enforce it? And how do we understand it properly in a way that gives it consistency and objectivity across all battlefields and all cultures? That's really the challenge.
Maybe it's worth addressing, why do we need specific war crimes? Why wouldn't this type of behavior be covered by national law?
Oh, that's a good question. How long do you have? One of the beautiful things about the law of war, and I do think it's a beautiful thing, and I do want to spend some time talking about the elements of crimes in the Rome Statute from 1998. We're doing the 25th anniversary of the International Criminal Court this year, or at least the signing of the statute. And the elements of crimes give you, in the official UN languages, the acts, the conduct, the consequences, the circumstances. For the first time in human history, you have a template that can be extrapolated to every country around the world. And this is the beautiful thing about the laws of war, is that they infiltrate into national systems, but the word I use is they're transposed from international law, from international systems. So I can go in Russian or Arabic and talk to any professional soldier, and we share the same body of law. Now the question is, in your system, how do you charge that? How do you prove it? Where does the jurisdictional lines break down? But the underlying law is exactly the same, and that's the beauty of this field. And to the extent that a particular country is not enforcing that body of law, one of the other beauties of this field is that because you have what's called universal jurisdiction, if you violate the law of war in an international armed conflict, then every other country in the world has the right to prosecute you. So if your own country is not doing its job to properly enforce this body of law, and so war crimes law, very similar to the same provisions in the Genocide Convention or the Torture Convention or all the terrorism conventions, you would put war crimes law, particularly grave breaches, at the top of that list because every country in the world. So I would say it's a shared responsibility, both of the international system and other states, but the primary responsibility lies in that sovereign state.
This is an important point, Professor, which is if a war crime is committed, perhaps as part of an American operation, it wouldn't necessarily go anywhere past the United States if the United States looks into it, investigates, and prosecutes the crime.
That's correct. That's correct. And that's the fundamental pillar upon which the International Criminal Court is set up.
You actually helped to carve out these definitions of the elements of war crimes. Maybe you can explain that a little bit better.
Oh, sure, sure. In Rome, when we were negotiating the Rome Statute, and you have to go back slightly further, you have to go back to Nuremberg, of course, the big international military tribunal after World War II. And, Nuremberg was in its own way very controversial. On the one hand, you're prosecuting Nazi leaders, totally appropriate.
Professor, that wasn't a foregone conclusion. I believe, am I right, that some, including perhaps even Churchill, said just line them up and put them in front of a firing squad?
Official British policy said they should not have a trial, they should just do that. He did say that. And the idea is that the politics of victorious allies superseded a fair trial with public evidence, etc. And the Americans and the Brits and the French went out of their way to demonstrate at Nuremberg a process that was fair, that was transparent, with defense counsel arguing vehemently and rules of evidence and examination and cross-examination and documents made. So it really was, as Robert Jackson said, an incredible tribute that power paid to reason. And it really was a good faith effort to try to do justice. The problem was it wasn't permanent. It was temporary. It was ad hoc, and it also didn't really advance the law in war crimes terms. So that's why the International Criminal Court was needed, and the movement to start a permanent supranational court really began about the time of Nuremberg, no question, but didn't culminate until 1998.
This is the Rome Statute.
The Rome Statute, yes. In the Rome Statute, we did something that was truly remarkable. We said, well, wait a minute. As a matter of customary international law and state practice, here's this other cluster of crimes that are absolutely committed in an international armed conflict, specifically delineated in 8.2b. And then, revolutionary, you have this whole section of crimes in a non-international armed conflict. Israel and Hamas today. Hamas is not a state, so there's a non-international conflict there. And so there's, in the Rome Statute, a whole body of treaty law. It's a beautiful thing because it gives you this continuity across all countries and across all contexts.
Today we're gonna speak a little bit more in detail about what's been happening in Israel and Gaza. We're both sitting in the United States. My understanding is that both the United States and Israel signed but did not ratify the Rome Statute. Does that mean that these law of war definitions don't apply to them?
Well, it depends on the treaty-based duty does not apply. But for us and the Israelis, the argument is very simple. The treaty says, in this complementarity principle, that domestic states get the first crack. And oh, by the way, let's be clear, you don't actually have to prosecute. You have to do good faith investigations. You have to apply the law correctly. And if there's a good faith decision not to prosecute, that satisfies the criteria of the Rome Statute. For the Americans and for the Israelis, there's not a belief that the court would actually respect those good faith decisions. And that's the most technically lawyerly account of that. I also think the domestic politics got in the way in both countries in lots of ways.
Maybe it's worth just mentioning that if you're engaged in a war or a military action, mistakes will be made, and not every mistake is a war crime.
There's no question about that. Here I quote a famous British general, Ian Hamilton, very famous, very well regarded until Gallipoli, when they didn't conduct a great operation and they lost. In his later work describing, it was sort of a history, he said, "On the day of battle, the truth lies naked on the battlefield. The following day, she has gotten up and put on her uniform," which is especially true in terms of parties trying to shape perceptions now in an interconnected, instantaneous social media world. And so anytime you see, a snippet of YouTube, you may watch 10 seconds and somebody says that's the war crime, always ask the question, well, what else is going on contextually? What are we not seeing? Or what are we not hearing? Or what radio transmissions are we not hearing? There's always a much richer context. And the law of war is designed to be a pragmatic, functional body of law. It's not strict liability because it has to work in the real world in the middle of a battlefield. So I'll just give you a couple of examples. In urban areas in Gaza, Israeli forces have a duty to warn civilians. And they have a whole array of techniques that they've more or less perfected through the years of how to warn civilians. The law says you have to provide an effective warning. So the technical thing is, what does it mean to have an effective warning? We have a lot of debate about that. But then it says, when circumstances permit.
I'm imagining two situations. One, the Israelis are trying to target, let's say, an important Hamas leader who's about to launch an attack on Israel. So there, under this hypothetical, there's some eminence, there's the fact that if you then give a warning, the person is likely not going to stick around for the attack. That might be an example where a warning couldn't be given. Whereas if you're trying to simply destroy an airfield because you don't want them to be able to launch some type of aircraft, there you might be able to give a warning.
All kinds of variations. I mean, the Israelis in Gaza have given warnings and literally watched what they know to be Hamas terrorists commingle with civilians evacuating an area. But they've done that, in essence, a trade-off, some degradation of the military efficiency in pursuit of the larger goal of protecting the civilian population.
Can I walk through some questions specific to the Israel-Gaza situation? What I'd love to do as well is to dig a little bit below the surface. We hear war crime regularly as, I don't know, almost a colloquialism. I'd rather talk with you a little bit to get to a better understanding of where war crimes are being committed and how actions that could be war crimes are judged.
Sure.
Maybe we can start with the attack on Israel. And I guess a good foundation, you alluded to it previously, but can Hamas, a non-state actor, can they even commit a war crime?
Yeah, that's a really important distinction because you have to understand from the start what body of law applies and to whom does it apply and how does it apply. So the basic rule is what's called combatant immunity. The idea is that if I'm a combatant operating on behalf of a state, it's immaterial how the war got started. So, for example, German soldiers in occupied Poland, illegal war to start with, or Russian soldiers in Ukraine today. They're not war criminals just because the war was begun with no proper basis under international law. They're war criminals adjudged because of what they do and how they do it. That's the first point. But the second important thing is, since you ask about Hamas, is that combatant immunity only flows from the sovereign authority of a state. There's a fundamental trade-off here in terms of human rights, because combatants can kill people and blow things up. Think Audie Murphy during World War II. We pin lots of medals on those people. But by the flip side, because you're a combatant, you can be targeted at any point, at any time. I mean, the classic example in World War II was General Rommel was home when the D-Day invasion happened. Could the Allies have bombed his house and killed him, even though he was a long ways away from the battlefield? And the answer is very simple yes,
Yes.
because he was a combatant, because he was serving the authority of the state. So the important point is that status based targeting. Okay? So unless you make the linkage, and the same thing could be said of Al Qaeda or ISIS or the Taliban, unless you make the linkage to a state, they do not have combatant immunity. But they do have some limited subset of rights or obligations under the laws of war. So that's the important point, is that everything they do is presumed to be criminal under one body of law or the other because they don't have the affirmative right as combatants to wage conflict in the first place. And if that were true, could you imagine an ISIS person saying, well, we hit the Pentagon on 9/11, and the Pentagon was a military target, and it had lots of military practitioners in there, therefore that was lawful and you can't prosecute us? Because that would have been lawful if we had been combatants fighting on behalf of a nation state. And we say, no, thank you very much. That's criminal conduct in violation of the laws of war. So that's the first thing. They don't get combatant immunity, but here's the power of customary international law. That what they are is what's called civilians directly participating in conflict. So you can't target them based on status. You have to target them or subject them to the rules based on conduct, what they're doing.
Israel can't treat Hamas members or Hamas militant wing as if they're soldiers.
In practice, they do, uh, but there's some odd technical reasons for that. One is a ruling from the Israeli Supreme Court acting as the High Court of Justice. Technically, they're what's called either terrorists or civilians directly participating in hostilities. And so there's this odd juxtaposition of different bodies of law. You have an absolute right to use force to protect your civilian population, but that's the law of self-defense, right? That's what we would call jus ad bellum law. That's what gives you that right. Um, Distinct, of course, from the law of war. The law of war does not give you the lawful right to do anything you want in the middle of an armed conflict and say, well, it's the necessities of war. No, the law of war operates from the ground up to constrain you. So in practice, they treat them as if they were combatants, um, but they're actually technically civilians directly participating in hostilities based on conduct.
I won't go into too much detail on what happened on October 7th, but many of the crimes that were committed were terrible crimes under Israeli law, including murder, rape. Is there additional gravitas to call those war crimes as well? Is there any reason why they should be considered war crimes rather than acts of terrorism or mass violence?
Oh, absolutely, in my view. But remember, I have to be careful how I say it. I say I do war crimes, and that doesn't sound right. What I do is I prosecute war crimes. So I think we have a duty under international law to call things what they are. If it's a crime against humanity, we call it what it is because that allows us then to properly prosecute it based on the correct body of law, right? So the labels don't matter in the criminal sense, but they absolutely matter in the political sense and in the emotive sense. And as we've seen in other contexts, they also have a huge amount of symbolic value. If I go to the mothers of Srebrenica and I say to them that what happened at Srebrenica was genocide, it's very different from saying, oh, it was just murder. It was just a random set of murders. There's another sort of a technical distinction here in that the law of war does apply. Remember that distinction between an international armed conflict that's conducted between two states and a whole body of law, and then the other, it's like a waterfall. The gradation of that is an armed conflict between a state and a non-state actor. The law of war absolutely applies to that setting because there's sustained violence, it's organized, it's planned, and not just in Hamas, but in other settings as well, with insurgents and non-state actors. That's what makes it an armed conflict to which the body of law of war applies as distinct from ordinary, just regular assault, right? It's a war crime because you're in a context where there's a sustained level of violence, and the Israeli Supreme Court has said this for a very long period of time. We're in an armed conflict with non-state actors, is the way they would say it. Same thing the United States said in Afghanistan against the Taliban.
In this case, it seems a little bit even more vague because non-state actors, but maybe semi-autonomous state actors.
Well, I mean, remember that the basic principle is sovereignty. The Palestinian Authority was created, which is a very important historical act, by the way. In the Oslo Accords, until the Oslo Accords, you never had an authoritative political body empowered to speak or negotiate self-determination on behalf of Arab residents in that area. It's a creation of the Oslo Accords in the context of the Palestinian Authority. Hamas is not in the Oslo Accords.
Right.
It's a non-state insurgent group that arises because of its own terrorist ideology. So the trick is this, and this is really important. I want people to understand this. They have no lawful right to conduct hostilities from the get-go. Why? Because they don't have combatant immunity. If you capture a Hamas operative, they are not a prisoner of war. Now, you may treat them as if they were a prisoner of war. You may give them all the same, if you were sitting in a spaceship and watching how they're treated, they might get all exactly the same things. But legally, they're not a prisoner of war. That's why every act they committed is criminal under either the law of war or domestic law. They have no scope of proper combatant immunity. Now, from the Palestinian side, Hamas would say, well, that's not fair. Why should the state get combatant immunity and the lawful right under international law to conduct hostilities against us, and we don't get that same benefit? And the answer is very simple, because you don't represent a sovereign state. That's the law, whether they like it or not. That's why all the terrorism treaties say terrorism, and I'll quote this, terrorism in all its forms and all its manifestations is unjustifiable and criminal. And then in the various formulations, it'll say irrespective of political, racial, ideological, philosophical motivations. So that's the trick, is that you're absolutely covered by the law of war because you have unlawfully chosen to participate in an armed conflict.
We could spend the entire time talking about what happened on October 7th, but I want to get to the Israeli military incursion in Gaza. But on October 7th, there were a few things that just jumped out as the crimes that are enumerated under laws of war. Would you be able to list off a few quickly, or maybe I could list them quickly?
You mean just on October 7th, focus there?
Just on October 7th, yeah.
Oh, kidnapping is never lawful under the law of war. And the technical distinction is if I have a combatant and I capture them, there's now a body of law that applies to that person. So kidnapping civilians is always a war crime. Obviously, all the crimes of sexual violence, horrendous crimes of sexual violence against civilians, never permissible in any context, under any body of law. So here the only question is, does the law of war apply in addition to Israeli domestic law, in addition to human rights law? And the answer is clearly yes. So those are war crimes.
I want to talk a little bit about Israel's actions in Gaza. First off, Israel declared a state of war. Can you declare a state of war against a non-state actor?
Sure, because it's a non-international armed conflict. There is this odd formulation in what's called the Israeli targeted killings case. It's the Israeli version of drone strikes. It's an old case. It's not recent law, so it wasn't just invented for this context. What the Israeli Supreme Court said was that, and if you go back to Guantanamo, this phrase should sound pretty resonant in the first Bush administration. The Israeli Supreme Court said that there's no such thing as an unlawful combatant or an unlawful belligerent. Very technically, because those terms are defined by international law. So it's kind of an oxymoron. If you're a combatant because international law grants you that status as an objective matter of fact-based determination. So logically, if international law grants you combatant status, it's an oxymoron to say you're an unlawful combatant or an illegal participant, right? So that was the Israeli government position, is that terrorists are unlawful combatants. The Israeli Supreme Court said no, what they are, and then they used the treaty language drawn from the 1977 protocols. They're civilians directly participating in hostilities. So you see the switch?
Yeah.
You've transitioned from targeting people based on status, who they are, or who they represent, you're a German soldier or a Russian soldier or an American Marine, into conduct-based status, civilians directly participating, and the law says for such time as they are participating. And so I'll give you just an easy example of what that means. There's a big debate about when that status, because remember, I can actually, under the law of war, target civilians who are directly participating in hostilities, and it does not count as the war crime of intentionally attacking civilians. Why? Because you're directly participating in hostilities. No question. The harder question is, when does that status change? When do you revert back to being a real civilian and therefore reclaim that whole body of protections?
It seems very complicated.
It is complicated. That's why we have to, in the field, as practicing attorneys, give very clear guidance to the IDF soldiers engaging in street to street fighting. If you see this, don't target it. If you see this, you may target it. Very clear instructions. And we also, the Israelis do something that I wished we did. And I would commend this to every other government in the world. The Israelis have a separate military command that reports directly to the Army Chief of Staff. So you publish these rules of engagement and the standards that you expect them to comply. This separate command on the battlefield has its own vehicles and its own logistics and its own command structure, and its job is to go where there are allegations of wrongdoing and collect the facts, collect the evidence. And in fact, that's so important that Israeli soldiers must cooperate. They cannot invoke a right to silence against that process,
Oh, wow.
right? That's important because you're trying to report directly to the chief of staff and say, what are we doing wrong? How do we learn from this? How do we correct these deficiencies? And they do it in real time. It takes us, in the case of the Kunduz investigation or other investigations, months and months and months and months and months to do our full-blown, administrative investigations. I wish we were much faster and leaner in doing it in real time, both to learn the lessons and improve targeting, but also to ensure compliance and discipline.
And to gather evidence while it's there.
That's right. The commander is not out there. He's relying on the discipline and the professionalism, or she is relying on the professionalism and the training and the character and the law-abiding nature of those forces to follow the law. It's a non-negotiable duty.
One of the claims of war crimes against Israel that's been the most common, I suppose, is targeting civilians. First off, what is the actual law on targeting civilians, and how would you assess that claim?
Well, like all areas, complicated. Give me a couple of minutes to explain it. I'll try to do it. I'm going to start my watch. 2 minutes and 45 seconds, which is record time. Number one, you never intentionally target civilians, ever. The civilians are not the target, because if they are, that's a war crime. That's why it's so convenient for Hamas to come in the media and maybe Hamas supporters and say, well, the Israelis are engaged in indiscriminate bombing, indiscriminate targeting. I don't believe that because I've worked with the Israelis. They know it's a war crime to intentionally target civilians. So I don't believe they're intentionally targeting civilians. What they are allowed to do is to always direct their activities at all times and all places against lawful military targets, meaning, in this context, civilians directly participating in hostilities, or the facilities, the bomb-making factories. On October 7th, you saw them flying in these little paragliders. If I can find the place where those things are being built, I bomb it. If I can find the place where the pipe bombs are being built, I bomb it. Or the rockets are being fired, I bomb it, right? Because that's a necessary component. It's a lawful military objective, etc. But remember, as I said, all of these parallel duties operate in a conjunctive way. I still have the duty to warn civilians when circumstances permit, which they're doing, not always perfectly. I still have the duty to take all feasible measures to minimize or eliminate civilian damage. So that means I might change the angle of attack of a weapon. I might choose a different weapon. I might issue a warning and give a certain amount of time based on this particular weapon. And then while that time period is going and I've warned civilians, change to a different weapon because it was feasible, it was pragmatic, it was achievable. And then lastly, Well, I think what you were alluding to is the rule of proportionality, which looks like you're targeting civilians because some civilians are dying or being injured. But again, the rule of law here is designed to be a pragmatic rule. I wrote a whole book on this, so I won't describe the whole book. But the idea is that you can never, and I'll quote the language, intentionally launch an attack in the knowledge, so it's an intentional thing, and I'm saying, I know I'm going to kill civilians and I want to kill them. I can never intentionally launch an attack in the knowledge. Doesn't mean it might not be accidental or unintended or, an easy example. When Hamas was firing rockets from the parking lot of that hospital at Al Shifa, and the rocket veered off course and landed in the parking lot and killed civilians, that's not a war crime because they weren't trying to target the civilians. They weren't intentionally launching the attack against those protected civilians. It's a tragic accident. So the crime is proportionality, intentionally launching an attack in the knowledge that such attack will cause damage. And here there's this really nifty combination of both treaty and custom. So what I'm about to tell you is part treaty language and part custom. Okay, so I can't intentionally launch an attack in the knowledge that that attack will cause damage to civilian lives or civilian property, or now we've added the environment. So the environmental protection is built into this body of law. That's clearly excessive.
Clearly
You see that room for
excessive.
discretion, you see
Yeah.
that room for good faith. Clearly excessive in relation to the concrete and direct, and the key word is overall military advantage, and then another key word of discretion, anticipated. I've got to make that calculus.
I think for a lot of non-military, non-experts sitting at home on their couches, they may have a different understanding than the rule of law or what our military would understand to be the rules. And maybe I could just give an example, and you let me know if I'm wrong. If we, in saying the United States, if we have a viable target that we think is a dangerous threat to the United States, and we have a legitimate reason to use deadly force, we might take that action even knowing that 10, 15, 20 civilians could be killed in that process.
Well, in the proportionality analysis, and by the way, this is very, in our practice and in NATO practice and in Israeli practice, these are very fine grained computer algorithms. You can map out on a battlefield as long as you have the intelligence and the information, pretty high degree of certainty what you're going to do. The uncertainty comes from not knowing exactly what's in that target. And I'll give you an easy example from the Gulf War. First Gulf War, we hit what was an Iraqi command and control center, no question. What we didn't know was that 5 layers below that, Iraqi officials had collected their families. So there were a lot of civilians below that, which would have changed the proportionality analysis. But we didn't know that. So that's why it says anticipated. So you really do have the duty to try to collect all the information you can, to try to make the most well reasoned decision that you can. And then in military practice, commonly, and I do think this is one of the effects of Afghanistan, that long term 20-year insurgency in Afghanistan, even if you could lawfully take that out, in the counterinsurgency context, we've tended to err much more on the side of not making that strike, finding another way to do it. Because war is permanent. Even this one, this is not a permanent war. And I mean that both in the narrow Hamas Israel context, but also the Palestinians at some point have to settle for a political viable deal on the table. And on the flip side, the Israelis at some point, if they ever want to live in peace and harmony and have a secure democracy in the Middle East, they have to go back to the deal that Prime Minister Omar put on the table or something like it. And at the time, you didn't have political leaders on both sides willing to make that deal. You won't have peace until somebody makes that deal.
This is such an important point, Professor, which is there's whether something is a war crime or not, and then beyond that, there's is it a smart military move? And those two things aren't perfectly overlapped. You might be able to strike way more targets than you would actually want to under the laws of war because it might not be good policy.
It leads to all kinds of problems. And the point is that this is a rule of professionalism and discipline and teamwork. It's an essential tool that allows militaries around the world to do almost impossible things under almost impossible circumstances because it's a shared professional obligation, just like doctors have a Hippocratic oath all around the world.
It sounds like you're making a case that the laws of war, they're not just tying the hands of military. They're actually strengthening the military by creating a more cohesive and resilient fighting force.
No question. But at the same time, they are tying the hands of the law of the military because there's a basic prohibition. You're not a mob. You're not some undisciplined group of teenagers out blowing things up just because it's fun. And it is fun to blow stuff up. I mean, we all did it when we were kids, right? Look at the 4th of July. Look at the kids blowing up stuff in the. It's fun.
Right.
But that never gives you the right to harm civilians, ever. It's both morally wrong and legally wrong. And that's what the law of war does. Again, from the ground up, this balance of accomplishing the military mission in the most professional way possible while simultaneously protecting civilians. That's why the rule of human shields is so important. I can never intentionally place my military targets near civilian objects. Hamas does it. Saddam Hussein did it. The Serbians did it. In the Balkans, it's commonly violated, but it's a war crime. It's a violation of the law. Why? Because I'm, through my own military actions, endangering civilians. This is why the Hamas control center under the hospital is a war crime, because you're intentionally taking advantage of protected status and depending on the other side's compliance with the law of war to gain an unfair asymmetric military advantage.
Yeah, I want to talk about this, Professor, because this is I think both fascinating and one of the deepest tragedies of this conflict, which is how does a military force engage against another force that doesn't follow the laws of war? And I guess, I think I know the answer, but why don't we get on the table? Does one party's breach of the laws of war, does one war crime justify another?
Yeah, and the simple answer is no, never. And the fact is that it's about my duties and my professionalism, and it's not about how you act. Now, the problem is, these are human beings. They're 18, 19, 20-year-old who are, deprived of sleep and not being particularly well fed and just had to miss. And they're also, by the way, almost nobody in Israel hasn't been touched in a personal way by this tragedy.
As well as in Gaza, I'm sure.
Whether it's an aunt or an uncle or a college roommate or whoever. So there's always the human impulse to just do vengeance and to dehumanize the enemy. This is why in World War II, when we say Japs and Jerry, the Germans, the problem is when you begin to think of these opposition fighters as non-human or subhuman, it allows you to create this dualistic moral code. That's what the law of war is designed to prevent. It says, I don't care who they are or what they've done, you can never intentionally target civilians. You must warn if circumstances permit. You must do everything feasible, practical to minimize or eliminate civilian damages. And on and on and on go. You must apply the proportionality principle. You must only, the principle of distinction, target your activities only against lawful military targets. And it just says these are my duties, irrespective of enemy conduct.
One incident that's gotten perhaps the most attention from the Israeli military incursion into Gaza involves this hospital attack. Now, you mentioned that the evidence suggests that it was actually a misfired rocket from within Gaza. But, as a thought experiment, there is an international law prohibiting attacking a hospital. There's also an international law saying you can't conduct military operations in a hospital. What happens when those two combine? Like, let's say, hypothetically, we're in a world where Hamas is literally staging rockets from a hospital.
Well, I mean, different hospital, different day. There's video YouTube footage of a Hamas rocket firing an RPG from the entry walkway into a hospital. I mean, so it's not a theoretical, hypothetical question. And the answer, and the same thing happened, by the way, to American forces in Grenada. You're taking fire from a hospital and they return fire. It really becomes a proportionality question and a question of, is there a better way to achieve the military mission, right? The harm that accrues, both morally and psychologically, from targeting a hospital, and the Israelis would say, we never targeted a hospital. We don't target hospitals. What we do is we target the people or the facilities that are illegally using those hospitals. And the law of war never requires you, I mean, it's just, it sounds weird to say it, but it never places an affirmative duty on someone to try to capture somebody, as opposed when you're entitled to use lawful force, lethal force, you're entitled to use lethal force. Now, if you choose not to, so that's the situation with hospitals or other protected targets, right? The Hamas and other terrorists use, for example, schools. The insurgency in Iraq used mosques as weapons storage facilities routinely and commonly. And so you have to go through this question of, my military objective is to neutralize the ammunition or the command bunker that's stored in that place. How do I do it? Well, there's a lot of ways of doing it. And it gets to what you were saying earlier. Even if I could legally target that thing,
Right.
oftentimes for pragmatic reasons, I won't, because there's a better way to do it.
Or the
Or
politics or the optics or the just human tragedy wouldn't be worth it.
exactly, exactly. And I think in democracies, there's also the particular, and this is a feature of democracies that, of course, Hamas does not share. There is a particular resonance to this notion that any sovereign authority comes from the people. I mean, this is our constitution. We created this, the United States of America, by the people, for the people, um, and on behalf of the people. So there's a particular resonance in the civilian marketplace, not just international media, not just propaganda, but the fact that I serve a democracy says I also have to be very conscious of civilian perceptions and the fact that we're not some undisciplined, lawless, because we're representing those people and the values of those people. And so, again, a pragmatic reason why I might not target the hospital, or I might target it in a different way. And military commanders are doing these things, again, with imperfect information and battlefield intelligence. Oftentimes it's wrong or inaccurate or incomplete. Weapons fail. I mean, it's not in a perfect technology application. Drones fail. I'm dependent on the drone to help me get it right. But there's an outage or the internet is what do I do? And you have to make these really hard decisions in real time. And I want to emphasize this. That's why we owe an absolute duty of professional oath when soldiers or Marines are doing their best to comply with the laws of war as they know them. That's what the law does. It protects them. It gives them combatant immunity. And now, if they've acted in bad faith, we investigate and we prosecute them. Or if they've intentionally committed crimes, we investigate them and we prosecute them. And the Israelis do this. But what we have to do is be very clear on both sides that we expect them to comply with the law at all times in all circumstances. But conversely, when they're doing their very, very best under extremely difficult circumstances to comply with the law, we give them that professional latitude to do so. In part because and this is what most lay people don't understand, is that the law of war embeds, implicit, woven into the fabric of this body of law, is that discretion. So, of course, when they exercise that discretion, who are we to second guess? Unless, of course, they acted in bad faith and ignored the rules or intentionally committed those offenses. And that's a hard line sometimes.
Professor, have you seen, I guess, in the coverage, and I know you alluded to having worked with the Israeli military in the past and having, some amount of respect for their procedures and protocols, but was there any of the strategies or actions that were being covered in the news where you thought to yourself, okay, well, this is an area where they may need to be extra careful with not running afoul of the laws of war?
I'll give you two examples. One is, as I said, the Israelis have had a lot of practice in these urban areas of warning civilians. They've invented a whole array of techniques. Roof knocking is the most famous. They'll drop a little munition on the roof as a warning to the civilians. Well, Hamas is smart. They figured it out. So what they did was build, they didn't have to go outside, and then they would essentially hold those families human shields. And so sometimes there's a tendency to say, well, we warned, so check. Now let's move on. But remember, you still have to have the duty to minimize or eliminate damage, to apply proportionality. They're all additive, to take all feasible measures, to do what's practical, what's pragmatic. So you can't just check the block. The other example would be white phosphorus. I testified to the Goldstone Commission in Geneva. The Israelis used white phosphorus in urban areas, and there's this long-standing trope.
What is white phosphorus, Professor?
It's a chemical that's typically delivered through artillery shells, a similar principle to napalm in Vietnam, but it's a chemical fire. White phosphorus typically used to set up a screen. It has thick white smoke. So if I'm going to move across an open area and I don't want a machine gun shooting at me, what do? I put a big cloud of smoke out there. They can't actually see me. Now, they may shoot blindly, but it also obscures vehicle movements, etc. It is not a war crime to use white phosphorus in civilian areas when I'm using it for a lawful purpose. That simple. If I'm using an incendiary munition in a way that endangers civilians, it might be a war crime. And again, these are fine-grained distinctions where another technical reason, and this sounds parochial, it is complicated, and the law of war requires, as a specific treaty rule, that commanders have legal advisors to help answer these kinds of questions. That's why, because it's complex.
How about the withholding of supplies? I mean, this is a unique. I mean, not unique in the annals of war, but unique in the sense that Israel controls the perimeter of Gaza, and in this case, at some point, had cut off water and electricity. Did that strike you as a concern for international law purposes?
Yeah, that's I think the hardest, most difficult, complex decision that's been made. I'm working on a book now called The Humanitarian Imperative. And the idea is that the law of war and jus ad bellum and the R2P, what we call the right to protect, always have humanitarian exceptions for food and medicine. Um, the idea, as happened in Saddam's invasion of Kuwait, that babies in incubators are dying because you shut off electricity, that's a moral problem and it's a legal problem. If I'd been the Israelis, I would have said, you can come get food at these places in these ways. And we're going to search you on the perimeter and we're going to make sure you're not weapon. And of course, what would Hamas have done? They would have targeted those places. That would have been the right answer to set up, once an area is cleared, electricity is back on. And I think this is a really pragmatic thing. The Israelis are not occupying Gaza. Hamas runs Gaza. But now that they do control parts of Gaza, I think they have a pragmatic duty in the longer term interests of peace to show regular Palestinians living in Gaza life is better when you're not living under Hamas. You get electricity, you get clean water, you get medical supplies, you can get to the hospitals. And there's a degradation in every person I take out of the force to go help Palestinians get to the hospital is one less person or one less vehicle that can join the fight. But that's the strategic imperative here. But that's why you fight a war, is to help set the conditions for peace. And that's part of the conditions for peace, is that people eat. Now, there's a separate war crime, which I don't think was violated here. And the war crime is intentionally using starvation as a method of war. Right? The idea is that I'm starving everybody just because I want to starve
Like
civilians.
an old school siege of a castle town.
Exactly. And the problem is, again, the law has changed. People talk about bombing civilians, and they always use the examples from World War II of the Dresden bombings and the Tokyo bombings and Allied bombings that were essentially area bombings. And then lay people would say, well, okay, you're doing indiscriminate bombing in Gaza. That's where that propaganda or those press headlines come from. No, the law requires now, today, in the year 2023, even in an urban area, I cannot treat the urban area as the target. I have to have a disaggregated, specific targeting decision for each and every specific target within that urban area. That's an example of the law changing from World War II to today. So, with respect to sieges, a big siege of a whole area would be totally unlawful, as would, footnote, I'm a law professor, so you got to have a footnote. Footnote, the Russians in Syria targeting medical convoys, targeting humanitarian convoys, or the Russians in Ukraine targeting intentionally those things. The Israelis haven't done that. They've tried to facilitate the entry when they could help ensure that it wasn't going to Hamas to facilitate the war effort. You know, take the example of fuel, where you know that hospital generators are being run for fuel. If I were the Israelis, I would have said, I'm going to take fuel to the El Shifa hospital tomorrow, and I'm going to drive down this road at this time, and I want UN observers to come with me, and I want Arab observers from the Arab League to come with me. I'm coming in peace to bring fuel to El Shifa or cooking fuel to this place. And if Hamas violates that, they're doing it in front of the entire world in the Arab League. But call their bluff. Make them do it. Um, they did cut off food and electricity in the early days, but they began to very quickly restore, for example, communications technology and fuel and etc.
One last specific crime involves kidnapping, and you mentioned kidnapping is never permissible under international law. It is a war crime. But given that, are there still obligations that is that crime compounded if the person kidnapped is treated poorly? I guess I'm just confused on how to interact under an entirely illegal action, and then how do the negotiators participate and try and create a resolution?
Yeah, that's why you call a law professor. The correct legal term is outrages on personal dignity. So the initial a priori crime of kidnapping is then compounded by, for example, things like sexual violence, things like even basic human rights, like depriving that person of the right to practice their religion. So no, there's never excuse, and it's always compounded. Adequate food, the right to practice your religion, the right to, and the big one that gets me, the International Committee of the Red Cross. Hamas is absolutely compounding their violations by not allowing the ICRC access. And the ICRC operates on a confidential basis. Their job is to just be nonpartisan, to be unbiased, and just act to protect the interests of the people. That's why you don't see the ICRC out making public statements. They just kind of stay low and stay non-controversial. As part of the truce agreement, Hamas agreed to let the ICRC visit with every other hostage, which they're now violating, according to press reports. And I suspect that Hamas is so good at the propaganda, if they were allowing the ICRC to visit all the rest of the hostages, and there, the ICRC does what they do. They take letters from home, they take birthday cards, they take food, they check to make sure you're not being tortured or sexually abused. That's what they do as the independent, impartial, apolitical observer, because you got to have somebody, if you're in those circumstances, whose only interest is your personal human dignity, your personal welfare. And both sides have that obligation here.
Professor, I know that you have actually a lecture that you're about to give. Before we let you go, is there anything that you are seeing in the news that's kind of jumping out at you as, wow, they've got this international law stuff backwards?
Well, I mean, we talked about this earlier, but the duty of all states to prosecute alleged war criminals, to fully investigate, which is derivative of the individual soldier and the individual commander's duty. That's why in the American and the Israeli military, if you receive an unlawful order, you have a duty to disobey that order, right? And so as a result, there's a duty, an affirmative duty mandate to investigate offenses and to collect facts and to collect evidence, and then a collateral duty where the evidence shows that there's a good faith basis to charge that. You either charge it in the International Criminal Court because the ICC does have jurisdiction over crimes committed inside Gaza, not inside Israel, but inside Gaza, um, or in the domestic courts, or in the court of some other country. And one of the problems here is this notion that Hamas has, and I talked about this earlier, combatant immunity. Everything they do is criminal. But on the flip side, just because what they did was criminal doesn't mean that the Israelis can do anything they want to do. And this is one of the great myths, is that the Israelis don't care about the law. That's actually not true in my experience. They care a great deal about the law. They do really incredible things to try to comply with the law, not perfectly. So from the Israeli side, what I would like to see is more transparency. But that's a myth, that they don't care about the law and that they're treating Arabs as second-class citizens. If you read some of the protests, you'll say there's a genocide going on in Gaza. That's simply not true as a factual or legal matter. There's no genocide on the ground conducted by the IDF inside Gaza. There's an armed conflict governed by the laws of war, albeit imperfectly at times. And where it's imperfect, they have the duty to investigate and to disclose that and to share evidence to get it prosecuted where it's appropriate.
Professor, thank you so much for your time. This conversation, I believe, is truly invaluable, and I appreciate you squeezing us in today.
I appreciate your time. I think it's important for people to really get to the granular details here and try to figure out what the law is, and not just to follow the headlines or the big picture things, to try to figure it out in good faith. And on the flip side, I would say we have a duty as citizens to ensure that those who are representing us respect and comply with this body of law. That's what it's all about.